And welcome. I'm John Armour, the Dean of the Faculty of Law, and I'm delighted to introduce our lecturer this evening, Professor David Enoch. It's such a great pleasure to see so many of you here in the Gulbenkian Lecture Theatre, and also we're very happy to be able to welcome so many members of David's family. David studied law and philosophy together at Tel Aviv University, then clerked for Justice Beinish at the Israeli Supreme Court. From there, he travelled to New York to pursue his PhD in philosophy at NYU under the exceptionally distinguished guidance of Derek Parfit, Tom Nagel, and Hartree Field. After brief spells at Rutgers and then Tel Aviv, he took up a joint appointment in philosophy and law at the Hebrew University in Jerusalem in 2003. He's been a faculty member there ever since, and from 2015 holding the Rodney Blackman Chair in the philosophy of law. He's also been a visiting professor at several leading US law schools, including Columbia and Texas. And over the years, he's won numerous prizes and honours. I say numerous because there are literally too many for me to recount. Amongst the more significant, his papers have been selected by the Philosopher's Annual as being amongst the 10 best published papers that year, not once but twice, in 2012 and 2017. David works on political, moral, and legal philosophy, and he's made really profound contributions to all three. Obviously, he's a super smart guy, but it's my strong sense that he's not in the business of demonstrating that. Rather, his concern is with working out what's right. He's perhaps best known for his defense of robust moral realism. That is, as he puts it, that moral claims have an objective normative truth which can be discovered through debate and inquiry rather than created. In his 2011 book, Taking Morality Seriously, he made important, new, positive arguments about this position. Amongst these, he points out that it feels to us as humans participating in moral deliberation that what we're doing is trying to find an objectively right answer. And he argues that it follows from this that to engage in moral deliberation presupposes commitments to belief in objectively right answers to moral questions. He's more recently also made significant contributions to political philosophy, foremost amongst which is probably his critique of public reason. And along the way, David has made a range of contributions to legal philosophy. These include a critique of the concepts of moral and legal luck, an account of the appropriate use of statistical evidence. But perhaps most confrontingly for us lawyers, he's also argued that general jurisprudence is, as he puts it, not interesting. If, as David does, you defend robust moral realism, you're committed to thinking that there's an objective truth out there that should govern yours and others' actions. Discovering that forms his benchmark for what is an interesting question. But while law is normative, its normativity is not what he calls the full-blooded normativity of metaethics. Rather, it's a formal normativity derived from the postulates of the legal system, which he argues is comprehensively less interesting. As you'll hear in a moment, David sets out his positions with exceptional clarity. He manages to convey very complex and subtle points so that even the non-specialist can follow the gist, yet punctuates with reservations and queries that convey the sincerity of his commitment and his humility as a scholar. As well as being outstanding scholars, we also expect our statutory professors to be intellectual leaders. David has shown and continues to show leadership both within academia and the wider world. He somehow managed to do this in both the law faculty and the philosophy department at Hebrew University. He served as chair of the philosophy department and chair of the appointments committee in the law faculty. Since arriving at Oxford, he's launched a new work-in-progress series for our legal philosophers and agreed to co-chair the jurisprudence research group. And of course, he's a board member for multiple leading journals in legal philosophy and mainstream ethics. David's time here with us in Oxford began in perhaps the most difficult way imaginable, as he arrived here physically on the weekend of the 7th and 8th October 2023. He spent his first hours in Oxford desperately working to secure the safety of his family, which he succeeded in doing. From the depths of this pain, his full-blooded commitment to moral realism led him to try to figure out and then act upon what is right. And David's two pieces in The Economist, which showed his anguish as he applied all his skill as a moral realist to such a painfully difficult problem, show as clearly as anything else, I think, the value of his approach. And because he's so clearly and honestly committed to discovering what's right, they landed with sincerity and humanity. Humanity will feature in tonight's lecture entitled Law, Philosophy and the Susceptible Skins of Living Beings. David's planning to speak for around 45 minutes, after which there'll be an opportunity for Q&A, which is, we understand, exceptional for an inaugural lecture, but we think will be merited by the engagement that David wants to generate this evening. And it will be moderated by our colleague, Professor Ruth Chang. Proceedings will close at 6:15, and with that, I introduce to you David Enoch, Professor of the Philosophy of Law.
Nothing at all out of the ordinary here. I want to start with just a few brief thank yous, and then we'll do some actual work. So first of all, I'd like to thank the Faculty of Law and Dean John Armour for, well, everything, and also for this lovely introduction. I want to thank my family who have come for this from other parts of this island and also from our tortured part of the world, and who have been supporting my Oxford adventure. This obviously goes mostly to my wife and kids. I also want to mention my father, who died long before I decided to go for an academic career. He would not have approved of that choice, but he would have been very happy to be here today had he been able to. I also want to thank all those who worked on making this event possible. So at the Faculty of Law, Michelle Robb, Sidney Tui, and Luke Webster for all the relevant administrative work on this. I want to thank my colleague Ruth Chang for chairing the Q&A, but also for a lot of other advice along the way. And I want to thank Philippa Paes. I didn't see, where is he? Over there, of course, you're over there. My RA, who has been wonderful about coordinating a lot of this. And all of this despite not even agreeing with the main line of the lecture. And I thank all of you for showing up. Okay, so this is supposed to work somehow. Right, so I'm going to be relying rather heavily on this quote from Catherine the Great. As quotes go, we're not entirely sure she said it, but she did say at least something in the vicinity in her correspondence with Diderot, and this is the translation to English. You philosophers are fortunate. You write on paper, and paper is patient. Unfortunate empress that I am, I write on the susceptible skins of living beings. And I hope you'll see rather shortly how relevant it is. Okay, so let's talk a bit about the import temptation. Lawyers discuss causation all the time. Right? Causation is extremely important, both for, say, deciding real-life cases, but also for legal theory. So we need, for many purposes, we need a theory of causation in the law. Metaphysicians also discuss causation, and they do it quite well. In fact, the most impressive discussions of causation come, I hope nobody will be offended, from metaphysics rather than from legal philosophy or legal theory. So there's a very understandable temptation. The temptation is to take our best conclusions, to the extent that we arrive at any, from the metaphysics discussions of causation and just to import them to the law. Take what we've learned from there, the most impressive discussion of causation, and apply it to the law. So for instance, if we think that causation is best understood probabilistically in general, maybe that's how we should understand causation in the law. Or if we think that causal contribution comes in degrees, maybe that's we should import that into the law, and so on for other matters having to do with causation. So that's one example. There will be quite a few examples that I'll just be going between them as we'll see how it goes. All right, here's another thing that the law and legal theory seems to take seriously. Knowledge claims are rather common, right? Knowledge claims are certainly common if you're doing evidence law, certainly if you're doing theory of evidence law. But they also are sometimes legally relevant, right? Sometimes there are doctrines having to do with the question whether somebody knew or should have known something. But, you know, epistemologists, some of them in this very room, discuss knowledge, and in fact do it reasonably well, right? The most impressive discussions of knowledge typically come from epistemologists, not from legal theorists, not even from legal epistemologists. So there is a temptation, and the temptation, I think, is rather understandable. Take whatever you've learned about knowledge in epistemology and just apply it to the discussions in the law. So if in doing epistemology, we've discovered that knowledge requires the elimination of relevant alternatives, you don't need to understand all of the details here. Trust me on this one. These are the kinds of things that epistemologists tend to say. Right? So if we've come to see that knowledge requires the elimination of relevant alternatives, maybe we can apply this to discussions of knowledge in law and in legal theory. If we've come to see that statistical evidence never suffices for justified belief and for knowledge, maybe we can apply this to the case of legal knowledge or to the cases in which the law talks of knowledge, and similarly for other examples of this kind. And you see how it goes. Whatever you lawyers or legal theorists want, or pretty much whatever you want, we philosophers have something to offer, something for you to import. Here are a few other examples that I'll go through rather quickly. So for many legal contexts, you may need an account of what an action comes to, what an omission comes to, what an attempt comes to. Well, fortunately, we have something for you. Philosophers of action discuss these things, and they often do a rather good job at it. So maybe we can import to the law the lessons from the philosophy of action once we're interested in actions, omissions, and attempts. We may be interested in intentions. For instance, in some parts of corporate law, you may want to know whether you can attribute intentions to corporations. And in some cases, you may be interested to know whether you can, say, talk about legal interpretation. You may wonder whether you can attribute intentions to legislatures or maybe to states. Well, there's this whole part of philosophy, the philosophy of mind, that tells, well, it does many things, but one of the things it does is precisely give a good account of, say, the necessary and sufficient conditions for intentions, or for some creature to have intentions. So maybe we can import those lessons to the law. You may worry about constitutional interpretation or meaning of legal texts. Well, the philosophy of language is very much into understanding meaning and maybe also into understanding interpretation, so we can import the lessons from there. And you see how it goes for many other cases as well. I should, from time to time, have a look to see that I'm still on the same line that I think I am. But right. So as my name for it, a temptation, suggests, I think it's going to be really important to resist this temptation. So I think it's going to be really important not to import, certainly not in this direct kind of way, the lessons of philosophy into the law. And in order to preempt misunderstanding or maybe dismissals, I want to make it clear that that does not mean that I don't think philosophy is relevant to the law or should not be taught in faculties of law. Right? That would make the occasion a little bit awkward. In fact, I'm a philosophical imperialist. I think that philosophy, when done well, is relevant to everything. But the when done well part there is important. And if I'm right, succumbing to the import temptation is not a way of doing legal philosophy well. The hope is not to end up with a conclusion against legal philosophy, but a conclusion that distinguishes between the right and the wrong ways of doing legal philosophy. Okay, here's the plan. So I'm going to start by talking about the mistake, which I think Catherine, somewhat charitably interpreted, got right. Then I'm going to raise an objection and address it having to do with natural language. Then I'm going to suggest or address the, well, if not that, what kind of questions. I'm going to try and go positive and see how philosophy can make a difference. And I'm going to generalize it a bit and end with a kind of a self-reflective thought about this very paper or this very text. Right. So let's talk about the mistake. And for that, I need you to cooperate. So I need you to go through this thought experiment in your own mind. Assume that you're an appellate court judge and you have to decide a case. And assume that somehow knowledge is relevant, maybe because the fate of the case depends on whether someone knew or should have known something, or something along these lines. And of course, many considerations are relevant for this kind of decision. We don't need to decide now what considerations are relevant, but you do need to see just how complicated such a decision can be, right? So the question how you should decide the case may depend on whether anyone's rights were violated, on what you owe the legislature by way of some institutional commitment or other institutional commitments. Perhaps it may depend on the effects on others, on incentive structures. Again, each specific suggestion here is controversial, but these are the kinds of consideration that if you are a conscientious appellate court judge, you're going to have to take into account in deciding the case. And I want you to think about the following question. Is the following consideration relevant? So there are all these other considerations in the background, things you're already taking into account, and then, well, on comes your clerk with a breaking news coming out of the epistemology seminar room. Perhaps, we've just found out knowledge actually depends or the level of evidence needed for knowledge depends on practical criteria. Or knowledge requires the elimination of luck-informing beliefs. Again, you don't need to worry about the details. This is the kind of thing that happens and should happen in the epistemology seminar room. So now the question for me is, how much weight should you accord this new piece of breaking news in the scheme in which you're already deliberating on all of these other practical considerations? In particular, is it possible that you were about to decide, say, for the plaintiff, but the breaking news from the epistemology room changed your mind? Now that you understand something better about the nature of knowledge, you see that you should actually decide for the defendant. So as you may have gathered already, I think that this thought is, the thought that this would make such a difference is ridiculous. I think it's ridiculous descriptively, so I would hazard an empirical speculation. No judge has ever changed their mind because of something like this. Or pretty much no judge. Right? But also, and more importantly, I want to say that it's ridiculous normatively. No judge should change their mind. So you already took into account, say, the effects in terms of incentives and their relevant considerations in terms of rights violations and institutional aspects and, I don't know, administrative costs and all of the practical things. I don't think you should ever change your mind based on the breaking news from the epistemology seminar room. Now, you may find this a little bit puzzling because how can a good judge avoid bowing their head in front of such news? I mean, this is news about the very nature of knowledge. How can you, the thing to remember here is that actually disambiguating is something that comes very naturally, not just even to mediocre judges. Right? So they say such things, Sure, the news from the epistemology room, I mean, these people are really smart and it may make a huge difference in how we understand the nature of knowledge, but we're talking about legal knowledge and it's not clear that it's the same thing. That's a very common, I think, or causation in the law, right? That's a very common thing for lawyers to say and think, and I think with good reason. We can even go a little bit more precise here, perhaps, and use subscripts. This is not something that judges often do, but philosophers sometimes do it, except I'm not sure you can see them on the, can you see the subscripts? Okay, right, so they can say something like, well, the news from the epistemology room is about knowledge sub E for epistemology. But what's legally relevant is knowledge sub L for the law or for legal knowledge. And at the very least, it's not clear that they amount to the same thing. Maybe we'll have some fancy argument to show that they do, but it won't be something we can take for granted. And one of the main points that I'll be making is that knowledge sub E and knowledge sub L are governed by different standards. Knowledge sub E is governed by the kind of standard that we use when we do epistemology. And knowledge sub L is guided by the kind of practical considerations that guide and should guide the law. So, I think that it's very clear that judges should be indifferent to this kind of breaking news from the epistemology room. And what this means, speaking a bit roughly, is that the law shouldn't care about knowledge. Or anyway, not in this way. There will be qualifications. Remember, if you're into philosophy, you should be very relaxed in this talk. We're on the same side. Okay? But it's not going to be in this way. And of course, the same holds for the breaking news from the metaphysics seminar room. And we can distinguish, say, between causation sub M and causation sub L. And similarly for the breaking news from the philosophy of mind seminar room, intention sub M for philosophy of mind and intention sub L. And maybe the breaking news from the philosophy of language seminar room. We can talk about meaning sub P and meaning sub L and so on. There is also the moral and political philosophy seminar room. But let's leave that out of the picture for a second. Well, for a few minutes. We'll get to it later on. Now, here's a point that, for me at least, is a key point. Because it's important for me to emphasize that what follows from this line of thought, from the breaking news from the epistemology seminar room line of thought, is that not just that the law shouldn't care about knowledge, or maybe epistemology and metaphysics and philosophy of action and so on in this way, but that nor should legal theory. That's an extra step, and it's an important one for me. But in order to argue for it, I think it will be useful to go through a very quick detour on statistical evidence, which is a topic that, as John mentioned, I've worked on in other contexts. Okay, so here's a kind of standard example in what's sometimes called the proof paradoxes. A bus causes harm, and we have two cases. In the first case, what we have is a 70% reliable eyewitness that testifies that the bus was blue. So an eyewitness testifies the bus was blue, and we have independent evidence showing that this eyewitness or eyewitnesses in those circumstances tend to be roughly 70% reliable. And legal systems, by and large, have no problem grounding a finding in torts against the blue bus company based on a 70% reliable eyewitness. In the second case, there is no eyewitness. But there is, in fact, uncontested evidence that the blue bus company controls 70% of the relevant market. So maybe in that neighborhood, or maybe in that neighborhood on the day or whatever, 70% of the buses were blue. But we don't have any eyewitness testifying that this specific bus that caused the harm was blue. And as far as I know, across jurisdictions, legal systems are not happy with grounding a finding in torts against the blue bus company based on the statistical evidence. And so, as you can imagine, there is this puzzle. The question is, what distinguishes between the case of the eyewitness and the case of the market share evidence, seeing that we've made sure that we keep probabilities the same across these cases, right? Why does it make sense to ground the finding in torts against the blue bus company in one of these cases, but not in the other? So that's an interesting puzzle, unfortunately not originally mine. I mean, I have some stuff to say about it, but I'm not the one who came up with it. There is a trend, I think, in the current literature to try and come up with an answer that is primarily epistemological. So some people will say something like, look, statistical evidence cannot, certainly not by itself, support knowledge. If the only evidence you have for some belief is statistical, then you can't know that that proposition is true. And that is all we need in order to explain the difference between, say, between the two cases of the blue bus company. Because the fact that the statistical evidence cannot support knowledge explains why we don't want to ground any finding in torts on it. But, of course, an eyewitness, even if it's not a fully reliable eyewitness, can support knowledge, and that explains the difference between the two cases. There are also other suggested solutions in the literature in epistemological terms. In terms of knowledge, in terms of the probability of achieving knowledge, I think there are even other alternatives. But I think that now we know better. We know better because we know that no breaking news from the epistemology seminar room should convince a judge to decide otherwise about these cases. But you see that the line of thought I've been describing, the epistemological solutions to the proof paradoxes, precisely assume that once we know better something about the nature of knowledge, the judge should play ball. And that seems to me clearly false. Now, that doesn't mean that the epistemological story is not relevant for the theory of evidence law. Because the epistemological story can ground something that is often called a debunking explanation. Let me give you an example from another context. Suppose you have a colleague here, and you you want to explain their pattern of marking, the marks they give on some papers. And suppose you find out that these markings actually are correlated rather nicely with how confident the tone of the student is. Suppose you further think that the tone, how confident the tone of the student is, should not matter to what marks people get. Well, in that case, you may still have an explanation of how this colleague marks papers, but you cannot have a justification, right? And in fact, you have a debunking explanation, that explains whatever it is we were out to explain, namely the marking patterns, but it does it in a way that presents it in poor light, in poor normative light, and should be discarded if at all possible. That colleagues should amend their ways. Similarly then, now that we know that the law shouldn't care about epistemology, if you are right, and what guides legal doctrine here is something about knowledge, then we should understand this now as a debunking explanation. We've just realized that the law shouldn't care about these things. If this still explains the relevant legal doctrines or patterns, that's some cause for concern. It's no longer a vindicating explanation, it's a debunking one. What this means is that if we are doing legal theory now, not deciding cases, there's a very low upper bound on how much this epistemological stuff can contribute. It can contribute by partly motivating a debunking explanation, and that's it. It cannot play a role in a vindicating explanation. If you're interested in understanding the nature of law in this way, epistemology cannot help. Right. So the lesson I want to draw from the detour is that if some news from some philosophical seminar room shouldn't matter to the law, it for the most part shouldn't matter to legal theory either. And that's at least one way of understanding Catherine's insight. Again, I don't have any historical pretensions here, right? I'm not saying that that's what she meant exactly. But I think, at least for someone like me, it's a very natural reading of this quote from Catherine the Great. The law, like Catherine herself, writes on the susceptible skins of living beings. And so the considerations that govern the law and that govern what the law should be like, they are practical. This doesn't mean they are consequentialist. I'm saying this because I've been suspected in the past for implying consequentialism. But that just does not follow. Whatever are the right practical considerations to guide us when we are writing on the susceptible skins of living beings, these are the right considerations to guide us, to guide the law, that govern the law, and that also should play this major role in doing legal theory. Philosophical niceties, thoughts about causation sub M, need be of no concern at all to the law. What this means is that there are really two problems. There are really two problems with doing legal philosophy in a way that succumbs to the import temptation. One of them is the one Catherine complains about, right? So you can't draw conclusions about the real world or say about legal reform by importing stuff from the epistemology or metaphysics or philosophy of action seminar room. But the other concern that's more relevant to what I do is different. And it may be thought that I'm here complaining about, say, how abstract some of these discussions are, but I have absolutely no problem with abstract philosophy. That's great. The problem with succumbing to the import temptation is not that it's abstract, but rather that it's going to be poor philosophy. Because when you're doing philosophy of law, you're supposed to be wondering and making, hopefully, progress about the nature of law, that thing about which you are philosophizing. And a really important thing to understand about the nature of law is that it writes on the susceptible skins of living beings. So if you're going to do legal philosophy, but ignore that, you are doing very poor philosophy of law. Okay. This concludes the very first part, what the problem is. There's a natural objection here that may have occurred to some of you already. I'm going to go through it maybe a little bit quickly, but we'll see. And here the main thought is the following. Forget, subscripts and intension sub L and intention sub P. Can we just talk about intention for a second? The way this word is used in natural language, in the languages we all speak and learn, well, naturally, like English or Hebrew or other languages of this kind. Well, so we can talk about intention without a substitute, or if you want, we can add the substitute NL for natural language. And then you may think the following. Surely the law speaks natural language. So when the law talks about intentions, the law talks about intentions, not about intention sub L. And surely when philosophers of mind want to talk about intentions, they want to talk about intentions, the kind of stuff we've all been talking about using the word intention, the natural language word intention. And then you may think, well, here's what licenses the import. At the end of the day, both the law and philosophy speak about intention in its natural language sense. Similarly for causation, knowledge, and so on. Okay, so the first thing I want to note about this is that even before doing theory, we know that something is wrong with this line of reasoning. And the reason we know this is that we know that judges should not be excited about the breaking news coming out of the epistemology seminar. Right? Had this been true, had this line of thought worked, then they should be excited about this kind of breaking news. So that's out. But still, it would be nice to say something more, perhaps something with some more theoretical depth here. So I'm going to try and do that. And here I want to offer 3 quick points. One about the law in natural language, one about the philosophy in natural language, and one about one a bit more general. So the tentative point about the law in natural language is that while it's of course true that the law works, we might say, in a natural language environment, perhaps it's, for instance, needed for the law to guide the action of normal people. They speak natural language. Still, it's a very common phenomenon that some terms get a special meaning within legal context. I use that in the written version. I use a case that I remember from my first year in law school. That's an old Israeli case that interprets the word document to include a car chassis because it was needed for, I think, the criminal offense of falsifying a document. Right? And that seems, if you are in law school, that seems very natural to you already. As well it should. So cases in which the law departs from natural language are very common. There's no problem with them at all. So even if the law works in the general environment of natural language, there's absolutely no reason to think that it has to stick to natural language. I think the case, I'm sorry, I'm being negligent here. Right. The thing about philosophy is, I think, the relation between philosophy and natural language is, I think, a bit more serious. The point there is that the concerns that we are out to address when we philosophize, those concerns are concerns we have before doing philosophy. Those are concerns that are put in natural language terms. And when you do philosophy, you want to address those concerns. You don't want to come up with a new term and a fancy theory about it. You want to address our concerns about knowledge, or our concerns about causation, or our concerns about intentions, and so on. So I think that there is here a close connection to natural language. But I think that here too, we shouldn't exaggerate. So I think that natural language is the starting point of our philosophical concerns. But once we do theory, we may depart from that starting point. For instance, we do this in scientific contexts all the time, right? So I'm assuming that when people started studying the biology of fish, they would have given whale as a paradigmatic example of a fish. But once they did some theory, it became clear that in terms of the coherence of the theory or whatever other theoretical payoffs we get from the theory, it's best not to classify a whale as a fish. And with time, even natural language arguably changed its ways accordingly. I think something similar, it's just an analogy, but still works in philosophical context too. So it's quite possible that the best theory of knowledge will have to depart in some ways from the natural language use of the word, and similarly for other philosophical concepts. So even when it comes to philosophy, the relation to natural language is not quite as immediate. Yeah. And then there's another thing to remember here. And that's the distinction roughly between core and periphery cases. So maybe in many cases there's going to be an overlap between the legal use and the philosophical use because they both start from natural language. And that's perfectly okay. But that's precisely not going to be the case in the cases we're interested in. Because the cases we're interested in are the controversial cases. They are the cases that are of interest to theorists. The very fact that the case is controversial and theoretically interesting shows, or at least pretty much shows, at least indicates that it's a periphery case. And in such cases, natural language is typically indeterminate. Typically, natural language will not be of extreme help here. In the written version, I also quickly go through a more political version of this objection, but I'm just going to put this to one side now. Okay, so here's the plan again. We already talked about the mistake. That's the one that Catherine got right. And we talked about the objection from natural language. And you may be losing your patience now. Well, you promised us that philosophy is going to be relevant. If not in this way, how? Philosophy is of value when it is not because of its implications or policy recommendations, or at the very least, not only because of these things. It can be of value without practical implications. So if the only problem is that it's going to be hard to draw any practical conclusions or implications, then it's not that bad. That's okay. We can do theory. That's fine. The more serious problem, at least as I was putting things, was that philosophy, in a way that succumbs to the import temptation, does not promote the understanding of the law. Now that's painful, right? But once we understand that that's the problem, then I think it's clear what the solution should be. The solution should be to philosophize about the law all the time, keeping Catherine's insight in front of our mind's eye. And in this spirit, I want to suggest a few ways of doing that I think can work. So here's one thing that we could do. So this is Hilary Putnam, who says somewhere that the problem with just giving up on philosophy is that bad philosophy is omnipresent. Right? You can't do without philosophy. It's either that the bad philosophy is going to win, or if you want to fight it, you have to do better philosophy. And I think that he's right about that. So at least one thing that we can do when doing legal philosophy is precisely help people avoid the import temptation. In fact, this is one of my hopes for this paper, right? That it will help avoid this problem, and maybe it can help avoid other confusions and so on. Skipping here a little bit in the interest of time. But I also want to say that it would have been especially depressing if the most good philosophy could do was to minimize the harm done by philosophy. I'm not sure that if you take this to your administrator, the Faculty of Philosophy will get more budget. So I want to suggest some other ways in which philosophy may still be relevant to legal philosophy without succumbing to the import temptation. Now, the way I put the import temptation was as if it was about entailment. But perhaps we can go for something less ambitious than that. So here's the kind of reasoning that I was out to reject. Someone said, here's our best account of interpretation from the philosophy seminar room, so this is what interpretation comes to in legal context as well. That is a paradigm of the fallacy that I'm warning against tonight. But here's something much less ambitious and more sensible. Something like, well, here's a promising account of interpretation from the philosophy seminar room. So this is an account that may be worth considering in the legal context as well. So you use the relevant stuff from philosophy as sources of ideas. But then, of course, and that can be very productive, obviously, but then, of course, the legal theorist still has to think whether this idea makes sense in the legal context. That is, whether this idea makes sense when written on the susceptible skins of living beings. So there's some contribution here to philosophy. It starts, as many good things do, with lower ambitions, but it has something to contribute, at least. Here's another way in which philosophy may be relevant. So some parts of legal philosophy are really just straight up moral and political philosophy, except applied to the law. For instance, here are some examples. If you are discussing questions about, say, the limits of criminalization, you are doing political philosophy and you're applying it to the criminal law. Or if you're discussing the duty to obey the law, you're doing moral and political philosophy, and you apply it to something that's relevant to the law. And similarly for other topics as well. So the main thing to understand about moral and political philosophy is that many of them are going to be relevant to the law without the need to import anything. So the stuff for moral and political philosophy doesn't lose its value or its force when it's about the law. It has the same value and force it always has, even when applied to the law. And this means that the breaking news from the moral and political philosophy room may be relevant legally in ways that the news from the metaphysics and epistemology seminar room are not. That doesn't mean that Catherine's insight is no longer important, but it's important in a different way. It dictates, I think, what kind of, I'm going to focus on political philosophy, what kind of political philosophy is relevant to legal philosophy. And this is something that I'm going to skip for the most part, so just mentioning it very quickly. Political philosophers often distinguish between doing ideal theory and non-ideal theory. Ideal theory, you may search for the best principles of justice under the assumption that everyone will play along. That can be a good project in political philosophy. But if you're doing non-ideal theory, you're going to ask something like, what are the best principles of justice for a society roughly like ours, where we are guaranteed that not everyone will play along, although some people will and some people won't, and we can have some evidence as to what level of compliance we'll have, and so on. So I think what follows from Catherine's insight to how seriously we should take news from the moral and political philosophy seminar room is that when it comes to legal philosophy, what we should be doing is non-ideal theory. That doesn't mean we shouldn't also be doing ideal theory. That's fine. Just like doing metaphysics is fine. It's just not a very good way of doing legal philosophy. But I'm going to skip this now, and well, I have this thing on the presentation so that you can see how smart I am and how many more things I have to say. But we're going to skip this nonetheless. Okay. And here's another, pretty much, I think, the last one. Yeah. The last way of thinking about, in which philosophy may be helpful here. And that's by thinking about what I call bridging principles. So I've been insisting that no proposition about causation sub L follows from one about causation sub M, or anyway, not on its own. But if we're allowed to use some auxiliary premises, then perhaps something does follow. So suppose you have independent reason to believe that no one should be held liable in torts for harm unless they caused sub M this harm. Caused in the metaphysical sense, this harm. I'm not defending this claim now. I'm just saying, if you do have independent reason to believe that, then we can call this a bridging principle because it bridges the gap between the metaphysics seminar room and what you're going to be doing in deciding cases or in doing legal theory. And such bridging principles can be very important, but they are very important only if there is this independent reason to accept them. That at least gives us a kind of a schematically a way out. So here's how all of philosophy can be relevant if you can defend such bridging principles. I gave an example of one. Now you may be concerned that, yeah, it gives you schematically something that can be done, but we have some reason to suspect that we will never live up to this scheme, right? Because if something like this works, then suddenly the judge has to be eagerly awaiting the breaking news out of the metaphysics seminar room. And we already know that that's implausible. So I think this is often the case, but not always the case, because philosophy also has rooms for moral and political philosophy. And here are some examples from there. So you may think, for instance, that it's wrong to this should be to convict. Not even a single presentation without a typo. Oh, it is corrected there. Just on my, okay. No, it's wrong to convict someone for an action unless they're blameworthy for it. That sounds like a fairly plausible thing to say. But blameworthy there should probably be understood in the moral sense. So it's a kind of bridging principle between law and morality. Or maybe you think it's wrong to punish someone disproportionately to the extent of their culpability. Again, seems to be a kind of import from moral philosophy. And I'm okay with that. What this means is that I think that at least sometimes judges should indeed be sensitive to the breaking news out of the moral and political philosophy seminar room. There may be other examples. I'm going to skip them. I do want to note the following. Even an initially plausible sounding bridging principle may have to be rejected further down the road if it yields a sufficiently implausible conclusion. So you may think, sure, this principle about causation, causing sub M harm and liability in torts, this makes sense. But then you see, well, but that means that judges should be really sensitive to the news coming out of the metaphysics seminar room. That may be a good enough reason to reject the bridging principle, precisely because it yields such implausible conclusions. So I think that there's a kind of an upper bound on how these bridging principles can work, certainly if they're trying to bridge between the law and the non-normative parts of philosophy, physics. Well, epistemology is normative, but in different ways, not moral and political philosophy. But again, I want to emphasize, in all these cases, there's not going to be any case of import without independently plausible, substantive, normative bridging principles. What it means is that no one gets points, for instance, in debates over constitutional interpretation, simply by insisting on claims about what meaning just is. Sometimes that's how the rhetoric goes. And you can engage them about what meaning just is, that's fine. But another thing you can say is just point to the import temptation and say, well, that doesn't work. You have to give me a plausible, an independently plausible bridging principle that shows why the law should care about meaning thus understood. Here, as everywhere else, only normative answers answer normative questions. So one of the payoffs of this, I think, is that you can't hide the considerations that do the normative work. The real work is going to be done by normative claims, not by the nature of meaning or anything along these lines. So this concludes my suggestions as to positive ways in which philosophy can help by, for instance, talking about bridging principles. And this leaves us the generalizing point, to which I turn. So, as I said, one way of sort of a slogan version of what I said was that the law shouldn't care about philosophy in this way. Philosophy should not matter to the law. But we can now generalize in at least two directions. We can ask what other things should matter to the law, and we can ask to what other things should philosophy matter. And if you're really into generalizing, you may ask both at once. You may just ask, well, what should matter to what? This is not just interesting because generalizations are always interesting. This is interesting also because it's the beginning of an objection. It's the beginning of an objection because subscripts are a dime a dozen, right? We can just disambiguate to no end. And from this, it would seem to follow that nothing ever matters to anything else. Right? We should always just disambiguate. If it follows from my line of reasoning that nothing should matter to anything else, this would be some reason to reconsider. So the generalizing point is not just theoretically interesting as generalizations are, but also because it's the beginning of an objection. Now, I know it's getting late, and what should matter to what may seem a touch too general question for us to discuss now, but here are two quick examples. One is about science and the law. Should science matter to the law? So we can talk about causation sub S and causation sub L. Does that mean that what science tells us about causation is irrelevant to the law? That sounds a bit much. So here's my line. My argument in general applies. There is a need for a normative claim to show why the scientific finding about causation is relevant to the law. It's just that most of the time, we can omit such auxiliary premises like bridging principles or whatever because they are so clearly relevant, because we just take them for granted with context. And in that case, we don't need to mention them. Even here, I don't think that the bridging principles hold with full generality. So, as some of you know, discussions of causation, some say, well, maybe science shows that this causes that, but not in the sense we care about. Maybe that's proximate cause or something. Or maybe sometimes you say, well, I know that it's not exactly caused, but we're going to treat it as if it is for legal purposes, and that's okay too. But anyway, I don't think that this case, the asking about science and the law, is going to matter for as an objection to the general argument. Because I think, yes, the general essence stands. You don't just get to import things. You need a normative auxiliary premise, but we can typically omit it because it's so obvious in the context. Now, in the opposite direction, we may ask whether metaphysics should matter for morality. So going really quickly here. Consider our practices of holding each other responsible and metaphysical discussions of free will. Should we await the breaking news from the metaphysics seminar room before we are angry at someone who did something wrong, who wronged us in some way. That seems a bit weird, right? Or should we perhaps distinguish? Should we disambiguate? Should we distinguish between freedom sub E for ethics and freedom sub M for metaphysics? So I have to say I'm not entirely sure about this. Here are a few points, though. Here, too, as everywhere else, only normative answers answer normative questions. So you may want to ask whether we should, and if so, why we should care in holding each other responsible, care about, say, the metaphysics of free will. Here, too, there may be obvious auxiliary premises that do work. And I should also say that sometimes, perhaps in times that are especially exciting, it's actually not clear that we should care about the metaphysics. So to those of you who know, for instance, Parfit's discussion of personal identity, one way of understanding it is precisely saying, yeah, well, you can't just apply the metaphysics in ethics. We need to ask the normative question whether this metaphysical stuff is the kind of stuff that matters. Here's our plan, one last time. We talked about the mistake of the import temptation. We talked about the objection from natural language, and I hope I convinced you that that won't work. I suggested some ways in which legal philosophy can nonetheless help, and I talked briefly about these generalizations. But now, finally, you may ask, well, what is this text written on, right? So, law writes on the susceptible skins of living beings. Philosophy writes on patient paper. What is this kind of stuff, this paper, the one I've been talking about? What is this written on? Well, philosophy of law is about the law, but philosophy of law is an instance of philosophy. We write on paper. And that means that maybe empresses may be forgiven if they're not, at least not intrinsically interested in what we do or in this text. And it also means that practical considerations do not directly govern what we do. They may be indirectly relevant in all sorts of ways, but our success criteria are not practical. This is important just in case I haven't antagonized enough people this evening, so this is sure to antagonize some others. I think this is important because there's a trend in philosophy to have many philosophers who write as if they write on the susceptible skins of living beings, and so are much more concerned with the effects of what they write in the real world than with such things as the soundness of their arguments. They don't have an effect on the real world. Right? At least most of us never do. We should be careful here, as elsewhere. We can introduce very clean discussions. That's great, but the world is not quite as clean. So the distinction between those who write on paper and those who write on susceptible skins of living beings is not as clear-cut. There are going to be borderline cases. If you are one of those very few people doing philosophy or even legal philosophy who have a huge effect on the lives of real people in the real world, because all these judges are just awaiting our papers, then you may be a borderline case between Catherine, who writes on the susceptible skins of living beings, and philosophers who write on paper. Or maybe it's going to be a case in which the metaphor will cease to be productive, because it is, after all, just a metaphor. And that's okay. But the thing to remember, I think, is the following. Fortunate academics that we are, not many of us have the kind of influence that would be needed to generate such dilemmas. We can be quite content writing on paper. It's just that if we want to better understand the law, we should fully internalize the fact that the law does not. Thank you very much.